We are live at Queen's Park. The provincial government has scored a court victory in the fight to cut the size of Toronto City Council. Good afternoon. The Court of Appeal has stayed the ruling on the original legislation that would cut the size of Toronto City Council nearly in half.
So let's take a step back here for a moment. The province appealed a judge's ruling that the bill violated the Charter of Rights. Then the Conservatives drafted a new piece of legislation invoking the notwithstanding clause of the Constitution to override that judge's decision, which may now be irrelevant. Here is what the panel of judges said. The question for the courts is not whether Bill 5 is unfair, but whether it is unconstitutional. On that crucial question, we have concluded that there is a strong likelihood that application judge erred in law, and that the Attorney General's appeal to this court will succeed. So what does this mean for the coming municipal election? Let's bring in CTV's Colin DeMello with the details on the ruling and the fallout, and there is lots of it, Colin.
Well, let's answer that big question. October 22nd, what is going to happen? Well, when Toronto voters go to the polls on that day, they will be voting for a 25-member city council. That is now in effect because Bill 5, which was struck down as unconstitutional, has been restored. And today the government is gloating, saying, A, they're not going to have to use the notwithstanding clause, but B, that they were right all along, that they had the right and the absolute authority to be able to do this, and that they weren't trampling on anyone's rights in the first place.
It's all popping up.
This was the moment lawyers read the ruling. One of the Bill 5 challengers finding out they lost in court.
Obviously, we're disappointed because now I suppose the province gets what it wants.
The Ontario Court of Appeal granted a stay of the ruling by Justice Edward Belababa that had decided Bill 5 was unconstitutional. The three-judge panel called it a dubious ruling, saying candidates have no constitutionally guaranteed right to a 47-ward platform, and that Bill 5 does not deprive them of their constitutional right to say whatever they want about civic issues. In the legislature, the Minister of Municipal Affairs claimed certainty has been restored.
We're pleased that the Court of Appeal has granted this stay. This will allow the city clerk to go forward with a 25-ward election that is aligned with federal and provincial boundaries. It's a very positive result for the people of Toronto.
But the pleasure today is in sharp contrast with what the Premier said last week.
He's the judge. I'm the Premier.
Ford rejected the initial ruling and then invoked the notwithstanding clause. Why do you accept the decision of this court when you didn't accept the decision of the lower court?
Well, obviously we made a determination to appeal the last decision. The justices have said not only that they've granted a stay while our appeal proceeds, but they've suggested, the justices, that there's a likelihood that we could win on appeal.
The stay also freezes the Ford government's plan to invoke the notwithstanding clause. Provincial lawyers told the court yesterday they would forego Bill 31 if Bill 5 was restored. Opponents say it is still alarming.
The notwithstanding clause was wrong, is still wrong, and I'm very concerned that he's prepared to do that anytime.
With the decision now set aside, the nomination window for City Council will be reopened for 48 hours. And I'm joined live now by the leader of the official opposition, Andrea Horwath. Let me get your first take, your first reaction to what the three-judge panel said today.
Well, I mean, in some ways, it's not all that surprising that this stay was allowed because the election's upon us, and I think there needs to be some certainty there, and I think that's some of what they said. But look, what hasn't changed is that just because this is something that could have been done isn't necessarily what should have been done by our Premier. It hasn't changed the fact that this was done because Mr. Ford has a vendetta against some Toronto City Councillors and that he wants to control City Council from the Premier's chair. And it doesn't. The thing that doesn't change is that he did change the rules of the game in the middle of an election, which, whether it's something that's allowed because of constitutional language or not, isn't the point. As people that live in a democratic society, we would expect our governments to act in a way that's democratic, that people feel they're engaged with, that provides them an opportunity to determine their own kind of governance, if you will. So none of those things have changed. The other piece is that there's still uncertainty. I mean, this appeal has been stayed, but there's still a chance that this may at some point be overturned at some point in the future. And what does that mean about this election now that it's about to take place?
And the big question, too, is while Bill 31 isn't going to be passed right now, they're not taking it off their order paper, which means that it's still alive, just not being passed, and the notwithstanding clause is there ready to be used in case they need to use it. What does that say? I mean, they don't seem to be taking away their intent to use the notwithstanding clause.
Well, I mean, and that's exactly the point, right? I mean, what it's clear is that regardless, Mr. Ford was prepared to trample people's charter rights, and so notwithstanding the legal kind of decisions that have come, he basically said, it doesn't matter to me. I think that trampling people's charter rights is the right thing to do to get my own way. And when you have a premier that's that disrespectful of people's rights, or who's prepared to do that as a tool, is problematic. Just because it exists doesn't mean it should be used. And we continue to see it, as you said, looming as a possibility. And the fact that he said that he may use it in other circumstances as well is quite worrisome.
All right, Andrea Horwath, leader of the official opposition, thank you very much for taking the time to speak with us. Of course, Bill 31 is no longer going to be passed right now, but it is still there and available. This decision, this stay by the Ontario Court of Appeal, is the highest court in Ontario. So the only avenue now, some of the lawyers have said they may take this avenue, but the only avenue now to reverse the stay would be to appeal to the Supreme Court of Canada in Ottawa. Reporting live, I'm Colin DeMello.